Hello everyone. In this video, we are going to learn about the role of intellectual property rights in pharmaceutical industry. So, intellectual property rights they have been defined as ideas, inventions, and creative expressions based on which there is a public willingness to bestow the status of property. So IPR technically gives us the exclusive rights to the inventors or the creators of that property so that they can reap commercial benefits from their creative efforts. So there are several types of intellectual property protections like patent, copyright, trademarks, like that. And patent is a recognition for an invention which satisfies the criteria of novelty, and novelty that too in the terms of global, not local, which means if we are patenting something in India, that doesn't mean that it is novel in India. It has to be novel everywhere. It should be non-obvious and it should have an industrial application. So those type of patents, they go a long way and the investors can earn a great amount of money from them. So, intellectual property right is a prerequisite for the better identification, planning, and commercialization, rendering and thereby protection of invention or creativity. So, each industry should evolve with their own IPR policies. For example, the art industry have their IPRs, the pharmaceutical industries have their IPRs, the education industry have their IPRs so that they can manage their styles, strategies, and then their area of speciality. So, what is an intellectual property? So, intellectual property pertains to any original creation of the human intellect, such as artistic, literary, technical, or scientific creation. And intellectual property rights refer to the legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. So, this patent lies with you for a certain period of time. Please focus on this sentence. So these legal rights, they confer an exclusive right to the inventor for his assignee to fully utilize his invention for a given period of time. And it is very well stated that intellectual property play a vital role in the modern economy, because it has been also conclusively established that the intellectual labor associated with the innovation should also be given due importance so that public good emanates from it. So there has been a quantum jump in R&D cost with an associated jump in investments required for putting a new technology in the marketplace. And the stakes of the developers of the technology have become very high, and hence they need to protect the knowledge from the unlawful use, which has become very common these days. And they can at least protect their invention for a period of time, and that would ensure the recovery of the cost they have put in that certain experiment, and they can reap the benefits of their patent for at least some time so that they can get all the money back which they have invested in that particular invention. And intellectual property right is a very strong tool to protect the investment, time, money, effort, everything invested by the inventor or the creator of an intellectual property, because it grants the inventor an exclusive right for a certain period of time to use his invention for his own benefit. So this technically aids the economic development of the country by promoting the healthy competition and encouraging everybody and the industries also for the development and the economic growth of the country. So now let's have a brief history in IPR. So the laws and administrative procedures relating to IPR have their roots in Europe, and the trend of granting patents started in the 14th century. So in comparison to other European countries in some matters like England was technologically advanced and used to attract artisans from elsewhere on special terms. So the first known copyrights, they appeared in Italy, and Venice can be considered as the cradle of intellectual property system, as the most legal thinking in this area which was done here. So laws and systems were made here for the first time in the world, and other countries followed in the due course. So Patent Act in India is more than 150-year-old now, and the inaugural one is the 1856 Act, which is based on the British patent system, and it has provided the patent term of 14 years followed by numerous acts and amendments. So let's now discuss about the intellectual properties. So originally only patent, trademarks and industrial designs were protected as intellectual property, but now the term intellectual property has much wider meaning. And intellectual property rights, they enhance the technological advancement in the following ways, like it provides a mechanism of handling the infringement and piracy and unauthorized use of that particular intellectual property. And it also provides a pool of information to the general public, since all forms of intellectual property are published except in case of trade secrets. And intellectual property protection can be sought and intellectual protection can be sought for a variety of intellectual efforts, including patents and industrial designs, which relates to the feature of any shape, configuration, any pattern, any composition of lines and colors. You also have patents for the icons of the respective, companies, isn't it? And it also applies to any article, whether it is two-dimensional, for example, textile, or a toothbrush for that matter. So let's talk about the type of intellectual properties. So trademarks can be bought, sold, and licensed. So trademark has no existence apart from the goodwill of the product or the service it symbolizes. For example, trademarks relate to any mark, name, or logo under which trade is conducted for any product or service, and by which manufacturer or the service provider is identified. For example, on the right hand side, you can see that the Coca-Cola has a definitive form in which it is written. And IBM, you can see in the blue color it is written, and whenever you see it, you know what it is talking about. Nivea, Levi's, Vodafone, and Android, and all these things, these all are trademarks. Rights, on the other hand, relates to the expression of ideas in material form, and includes literary, musical, dramatic, artistic, cinematography work, audio tapes, and computer software. And geographical indications are the indications which identify as good as originating in the territory of a country or a region or locality in that territory, wherein a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. For example, you can see the geographical indication is given for Darjeeling, and you can see it is in green color, and a woman is holding the tea leaf in her hand. So this is how the geographical indications are, they are used. So now let's talk about the impact of pharmaceutical industry on patent. So there have been bad impacts as well as good impacts. For example, the bad impact is that because of patenting, there is too much rise in the price of the medicines, there is too much competition in the market, and there are many drugs which are in litigations. And the good thing for patenting in pharmaceutical industry is that they are responsible for the growth of pharmaceutical industries worldwide, and more resources are devoted to the basic research, and people are also outsourcing their work. So let's now talk about the type of pharmaceutical patents in India. So as you know, pharmaceutical industry is one of the most intense knowledge-driven sectors. So pharmaceutical research is very costly and unpredictable in nature. The outcome of the research can be in the form of a new inventive process and useful product or process. So this is highly competitive market, and it is imperative for the pharmaceutical companies to always protect their inventions from any unauthorized commercial use by acquiring patent rights over the invented product or process. So pharmaceutical patents in India can be classified under following categories, and this classification is based on the list of pharma patents provided by the Indian Patent Office on its website. So first category is drug compound patents. So these patents claim a drug compound by its chemical structure per se, and these patent claims as usually referred as Marcus type claims, and a Marcus claim is a claim with multiple functionally equivalent chemical entities allowed in one or more parts of the drug compound. So a drug compound patent provide the broadest possible protection to the company's product, because they have literally patented the chemical structure. So since other companies are not allowed to prepare such drug by any route of synthesis or sell any formulation comprising this drug before the expiry of the said patent. So no one can use it before the patent of the company which has created this patent before it expires. So no one can use it. Now the next type is formulation and composition patents. So these patent claims specific technology to prepare a formulation and or quantity of its key ingredient. For example, following Ayurvedic antiretroviral composition for a treatment of acquired immunodeficiency syndrome was claimed in an Indian patent number this. So you can see how it is written. So formulations are also patented. So now the third type is synergistic combination patent. So drug synergy occurs when two or more drugs interact with each other in such a way that it enhances or magnifies one or more effects of those drugs. So patents can be obtained on new synergistic combinations of the drug. For example, you can have two compounds, they can come from any background. You can, do a research on them wherein you show that when both the compounds were used together, it were beneficial for any particular disease or disorder. So this is how the synergistic combinations are also patented in India. Third, next is technology patents. So these patents are based on the techniques used to solve specific technology related problems like stabilization, taste making, increase in the solubility, etc. So these type of things are also patented. For example, following taste masked formulation was claimed in Indian patent number this. So this was it. So it says a pharmaceutical formulation having a masked taste, the masking of which persists during administration of the formulation, in particular in the form of a suspension in aqueous vehicle. So this is the explanation of what the particular patent was all about. So, those who are involved in technologies wherein the drugs can be stabilized or they can be dissolved in a manner in a body, in a sustained manner, or you can mask the taste of that particular drug, or you can increase the solubility so that it reaches in our body very soon. So these are called as technology patents, which are also allowed by the Indian government. Next is polymorph patents. So polymorphs are different physical forms or crystal structure of an already known compound. So polymorphs are usually prepared to reduce the impurities or increase the stability of the compound. For example, this is patent number 237261, which claims that the crystalline form of B4 of atorvastatin magnesium characterized by X-ray powder diffraction patterns. So this particular crystalline form, it showed the greater purity than the other, and the greater purity was actually 98%. Now the next type of patent Indian government awards is biotechnology patents. So biotechnology involves the use of the living organisms or biological materials in the preparation of pharmaceutical products. Biotechnology patents cover a wide range of diagnostic, therapeutic, and immunological products. For example, Indian patent number 234072, it claims an aqueous human serum albumin-free interferon solution containing an interferon alpha and a non-ionic detergent, a buffer for adjusting pH. So this is how the biotechnological things can also be patented in India. And then we have process patent. So a process patent does not claim the product, which means they do not have a drug to patent. In fact, they are patenting the process. So it covers a new and inventive process to produce a particular product. For example, the product will be same, but in the manner in which it can be produced there is going to be different in these type of patents. So now let's talk about how do companies manipulate the patent system. So we know that there is a growing trend of pharmaceutical companies and they're actively trying to manipulate and abuse the patent system to their benefit. So IMAC, which stands for Initiative for Medicines Access and Knowledge, they argued in 218 report, which was titled Over-Patented, Overpriced, and that the current system is out of balance as the drug makers, which are the pharmaceutical industries, they have transformed the patent system into a defensive business strategies and to avoid competition in order to earn outsized profits on medicines for many years, and which is beyond which was intended. So now companies, they are cheating, they are they're trying to make more benefit, and although they were given a specific period of time which was no less than 15 or 20 years based on where you are based, but then even then they are trying to reap more benefit from it. So University of California Hastings Centers for Innovation director and distinguished professor of law Robin Feldman adds that patents are supposed to last for a limited period of time, and after that competitors should enter to drive prices down. But that is not happening. Rather, drug companies pile new protections onto their drugs to extend the protection cliff. So let's now talk about the scale of pharma patent manipulation. So Feldman research, which looked at all the drugs on the market between 2005 and 15, and every instance where a company added a new patent or exclusivity, concluded that stifling competition is not limited to a few pharma bad apples. Rather, now it has become a common and pervasive problem endemic to the pharmaceutical industry. So she found out that 78% of drugs are associated with new patents are not new drugs, which means they are already existing. And almost 40% of all the drugs in the market had an additional market barrier through further exclusivities. So although this manipulation trend exists across the country and across the industries, Feldman research found that manipulative extension practices were particularly pronounced among blockbuster drugs. So more than 70% of the 100 best-selling drugs between 2005 and 15, they had their protection extended at least once, with almost 50% receiving more than one exclusivity extension. So IMAX 2018 report identified a similar trend among the 12 best-selling drugs in US in 2070s. And what they found was very shocking. They found that the drugs have an average of 38 years of exclusivity, almost double the 20-year original patent protection, and an average of 125 patent applications. The scale of the pharma patent manipulation is too much, and now it's time that we really, bring all this in public limelight. So I'm giving you an example of the bad behavior by AbbVie and Humira. So one of the worst offenders according to IMAC are AbbVie's anti-inflammatory blockbuster Humira drug. So both Feldman and Dutfield, they picked out Humira as particularly bad example of patent manipulation. So according to IMAC's 2018 report, this company has filed 247 patents application for the drug in the US with the aim of extending its exclusiveness for 39 years. And around 137 patents have been awarded till date. And this is in addition to 76 patents applications in the European Union and 63 in Japan. So Humira drug is currently the world's best-selling drug and the second best-selling drug of all the times. And it has generated around $100 billion in sales for AbbVie since it was launched in 2002. And it is responsible for the 2/3 of its total revenue. Imagine how much harm has been done. This is not a very good practice, folks. So IMAC concludes that AbbVie's pricing practices are protected by an aggressive evergreening patent strategy to extend the life cycle of this drug in order to, deliberately delay the competition. So they were to reduce their price, and this patent was to be open for the other pharmaceutical companies to come up with the same drug. But they did not do that because they want to delay the competition. And they do that by just adding the new clause to the existing patent. And this is how they keep on extending the extending the life of the patent years. So these profits are also connected to other practices by AbbVie that they have led to the price of the drug increasing 80% every year between 2012 and 2016. However, IMAC concludes that these are not consistent with rise in the price of the manufacturer inflation. So patents, like all good things, they must come to an end. So drug development is expensive and patents are important for creating the possibility of reward for their investment. And this cycle of innovation, reward, and then competition is being distorted into a system of innovation, reward, and then more rewards. So now companies, they focus on incentivizing companies to focus on drug development through a one and done approach, in which each drug invention which receive one and only one period of exclusivity, and this should not be extended further. This should end. So Dutfield suggests an alternative approach to incentivizing drug R&D. So at United Nations, there are protocols that the cost of research and development should not be recouped through high prices, but by other funding mechanisms in proportion either to the R&D cost or to the global positive health impact of the medicine in question. So while there are concerns about where exactly the other funding mechanism would come from, but this approach could help to resolve an unbalanced patent system and ensure proper rewards for the genuine innovations in disease areas or drug types where there are less potential profits, such as antibiotic vaccines against healthcare crises primarily affecting the developing countries. Thanks for watching. Please stay tuned for the next videos. Please like, share, and subscribe. Thank you.